My name is Bill Walters. I've been in practice in Denver for over 37 years. Currently, I'm a partner with the firm of Heizer Paul, which is a firm with 8 partners, a small boutique. I specialize in working with nonprofit organizations in particular, but over the course of my career have litigated, done transactional work, and was a prosecutor for a short time with the Colorado Attorney General's office. I think in terms of what it means to have gone through law school and graduate with a JD, and what are you now prepared to do, I think there are a number of issues. One touches on ethics, ethical behavior. Another touches on social policy and or on justice, which can mean a lot of different things, all of which are important, all of which need to be infused. But I also think that when I went to law school, the idea, and I've shared this with many people, is you would be able to do a lot of things and have a lot of options once you finish law school. And by your 3rd year, everybody was dutifully marching off to large firms or government offices or whatever it might be. Today, I think because the marketplace has changed, that there's probably another piece that law schools should examine, which is if it's true that a JD gives you options, what does that mean? Some schools, for example, offer joint MBA JD programs. You come out, you may be able to, run a company with a JD or whatever it might be. Others have international master's programs with a JD, so they can go in the foreign service. And those are more academic examples, but I suspect and I know, because I know a lot of people with JDs that don't practice law, that there are opportunities, but that students don't think about that. They may say, I want to do a lot of different things, but if they want to work for an international NGO, non-government organization, a JD would be very helpful. The way you learn how to think is very helpful. And I think that if law schools would also expose their students to other than the path of law, that would be a benefit as well. I think law schools, in making their efforts to better prepare students, need to continue the focus on case law study, preparing cases that way, getting the fundamentals that are in most of the first-year curricula. I think that has been done well, and I think it needs to continue. I don't think you walk away from that. I think as you get up into the 2nd and 3rd year, the Socratic method starts to get a little old, at least it did for me. And I think there are other pedagogies that are available. I'm not sure many law professors have been exposed to that, so I think law schools need to spend some time, if you will, training and exposing their own faculty to that approach, so that they can come to the classroom, if it's an advanced tax course or trial tactics or whatever it might be, that enriches the student's experience by approaching it from another pedagogical technique. I think it's interesting, there was a time when adjunct professors were quite popular in law schools. I think many law schools have gotten away from that. I'm not that intimately familiar, although I think the Association of Law Schools doesn't like it. It's sort of like having a football coach who doesn't teach at the school. But I think that there are there's room on faculties for that. And I think the practicing attorneys coming into the classroom working with students is a good piece of that. I think more and more schools are beginning to explore experiential learning. There are lots of different models for that. I think there's a place for that as well. And I think there's an expectation on the part of students that when they graduate, they should be able to walk into a law firm and have a pretty good idea of what's expected and how to do it. And how you get to that point, I think law schools can take a number of paths, but that's, I think, the ultimate goal that the students want, that the practicing attorneys in the profession want, and I would hope the law schools as well. Another piece, I believe, of the law school experience needs to be exposure, training, examples of professionalism, which encompasses a multitude of ideas and concepts. The one that immediately comes to mind, I think, for a lot of people is ethical behavior and lawyers acting ethically. We all know that we have rules of professional conduct that we're supposed to follow. But it also involves what it means to be a professional. I think historically and even today, lawyers are looked upon. We have a special status, we have a special privilege, and many lawyers give back to their community as a manifestation of their professional attitudes and their commitment of giving back, whether it's pro bono or leading community organizations, whatever it might be. I think today that it's that part of professionalism, sort of giving back. You find that many students in college now are doing, or even high school, community service credits. I think that piece of the model is going on, and I think it can be reinforced. I think the ethical piece and professional behavior, whether it's towards one another, one professional to another, whether it's directed at your client, to the court, to the judges, to whomever it may be, I think that, to my information, or maybe it's changing. When I went to school, it wasn't addressed at all. They began introducing some ethics classes. You have to take a class in ethics. I think a lot of people will argue you can't teach ethics. I think that's true, but what you can do is expose people to situations. So even in a contracts class, for example, if someone is presented with a contract and you're going to represent one side or the other, but part of the problem involves the fact that you already represented someone else, either directly or indirectly, what does that mean? How do we explore that? Where do we go with that? Now, there'll be that same tension. How much time do we spend on the ethics versus how much do we spend on offer and acceptance and consideration? But I'm a great believer in different words for this. For me, it's infusing the curriculum with not only the substance, not only the thought process, but with ethical scenarios and with professional scenarios that can be accomplished. I think if you chop it up, which a lot of people have done and continue to do, that you lose a very important piece of it, that it doesn't just come and go, it's there all the time. And being a professional is recognizing that. And if law school is about issue spotting, it needs to be about spotting ethical issues as well. One of the challenges that the profession has in dealing with recent law grads is how they determine, as they interview or maybe hire, whatever it might be, what that student has to offer. And I think, not just that they can write briefs and they give you a writing sample and that they made certain grades, but how have they manifested professional behavior? I think that's just as important for the firm. Firms live and die on their reputation. And if you bring someone in, you expect them to inculcate whatever the philosophy is of the firm, most of them very strongly centered on professional behaviors and professional standing in the community. They expect people to participate in professional activities, do pro bono work. I think that runs through many firms. And when a student comes to them, I think a lot of potential hiring firms want to know, what have you done? And it may be on a resume, but it's also if there is a move in law schools to incorporate more and more of these pieces as part of the overall education, I think that begins to create a comfort level. It used to be, if you went to an Ivy League school, that meant the doors were open and you had a guaranteed job. That's certainly not true now, but I would like to think that knowing employers of recent law grads will be looking at the school and whether this was a school that moved in a direction of preparing people not just in thinking or in substance, but in behaviors and modeling those behaviors. So the graduate coming from that law school comes in with a whole expanded set of credentials.